The Environmental Protection Agency. We've talked about this before, and now they're on the move. And by the way, I've told you, some of you folks who've listened before, I've told you that my legal foundation, Landmark Legal Foundation, we've been litigating against the Environmental Protection Agency on a number of fronts. And on one of those fronts, we sought, a long time ago, maybe 18 months ago, give or take, information about all the regulations the Environmental Protection Agency were working on and preparing to unleash on us under the Freedom of Information Act. And, of course, they dragged their feet. They delayed. They evaded. They made representations which were inaccurate. And finally, because you have to play these things out, we said to the federal judge, Your Honor, we've done all our discovery, we've done all this, and they've been misleading us, and they've been misleading you. And he agreed, and he wrote a scathing opinion. And we asked for the right to depose former EPA Administrator Lisa Jackson, among others. We also asked for the right to submit interrogatories to the Environmental Protection Agency to really dig into this. And they were granted. Our motion was granted. She will be deposed probably after the first of the year. Lisa Jackson will be deposed, and I will fill you in and let you know. She hasn't been deposed yet by any party, but she'll be deposed by us. And we'll find, and our mission is a public mission, is to gather as much information in this regard and make it available, and I will do that. But in the meantime, PJ Media, Bridget Johnson, EPA stealthily propels toward massive power grab of private property across the U.S. I'm telling you, folks, in every direction this stuff's going on. This is why I continue to say, to the point for some of you of annoyance, that we have got to get back to the Constitution. We can win this battle, win that battle, win this battle, but we have got to get back to our governing document. While the country is immersed in Obamacare headlines and a congressional tussle over delays and mandates, the Obama administration is stealthily moving toward unprecedented control over private property under a massive expansion of the EPA's Clean Water Act authority. And I'm sure I'll have a caller, don't you believe in clean water? I don't believe in tyranny. The proposed rule obtained by the House Science, Space, and Technology Committee in advance of EPA Administrator Gina McCarthy's testimony at tomorrow's oversight hearing widely broadens the definition of waterways over which the federal government has jurisdiction to as little as a water ditch in a backyard. You ever get a puddle in the backyard, ladies and gentlemen? Well, then you're covered. The Clean Water Act redefinition of waters of the United States would include all ponds, lakes, wetlands, and natural or man-made streams that have any effect on downstream navigable waters, whether on public lands or private property. The administration is trying to move forward with the rule at a breakneck pace, relying on the findings of a scientific report that hadn't undergone peer review at the time of the rule was submitted to the White House for approval. That's right, lawlessness in the name of law. The EPA draft water rule is a massive power grab of private property across the U.S. This could be the largest expansion of EPA regulatory authority ever, said Chairman Lamar Smith of Texas. If the draft rule is approved, it would allow the EPA to regulate virtually every body of water in the United States, including private and public lakes, ponds, and streams. Well, you know, I said some time ago, and I believe it, it's not going to happen, but I said some time ago, if this were a sane government, somebody would be facing impeachment.